Schenecker, case 11, CF 001376. Here for jury trial, having selected our jury last week. They were sworn, given preliminary and note-taking instructions. I understand that our jury is all present.
Yes, sir.
As a preface, I'm going to turn to counsel and ask if there are preliminary matters you'd like to address before I introduce you to your opening statements.
Yes, sir. The state has a motion in limine and a request for judicial notice.
Okay.
The shorter of the two is the request for judicial notice, which is pertaining to the January 11, 2011 calendar. I attached a copy of that calendar to the motion, and the state just suggests that it meets requirements of the rule, that it's a fact that's not subject to dispute and capable of accurate and ready determination by resort to sources whose accuracy cannot be questioned. So pursuant to 90-20212 and 90-203, the state has been requesting the court to take judicial notice, and if allowed, would be introducing and publishing that as Exhibit A. That's the only exhibit that is not on the list.
No objection.
Okay, we'll grant that motion without objection.
The second matter the state has is a motion in limine pertaining to a video that captures images of Ms. Schenecker being led from Tampa Police Department downtown to an awaiting vehicle outside. For reasons cited in my motion, the state argues that unless and until such time as a predicate has been laid that indicates that her appearance is indicative of her state of mind at the time of the offense, that its prejudicial value, until that time, its prejudicial value would outweigh its probative value because of the physical appearance that she demonstrates, and opinions that I have received from both defense and state experts that was likely the product of lithium toxicity rather than state of mind.
Yes, ma'am.
Judge, as to the ultimate issue of sanity or insanity, that video is not being introduced for that purpose. The defense is seeking to introduce that video for a variety of relevancy issues. That is the only video documentation that we have of Ms. Schenecker back at the time when she was arrested. It shows what she was wearing, the paper gown that was placed on her after her clothing was removed from Tampa Police Department. It shows what her state is when she is leaving just after being interviewed. As far as the interview goes, you can hear some of the shaking on the interview. The interview wasn't video recorded, so there's no documentation of that from Tampa Police Department or her appearance at the scene. It shows the police officers wearing big jackets because it was a cooler day, which they testified to. It disputes what I believe Officer Arnold's testimony is going to be, that Ms. Schenecker was handcuffed in the back. The video shows, in fact, she was handcuffed in the front. It is a visual of the lithium and coumadin toxicity that she had at that time, which goes into question of, it's a visual of how she appeared on that date. And for those variety of reasons, I believe that it's extremely relevant for the jury to be able to observe that.
And finally, Judge, if in fact Your Honor allows that into evidence, then given the proper reason for its introduction, the state would be seeking and would propose a limiting instruction at the time of the submission, since it's not offered for state of mind at the time of the offense. Because as the court's aware from the numerous reactions of common citizenry in the jury panel, many people drew conclusions of state of mind at the time of the offense from that video, and that's why the state suggests it's misleading and prejudicial to the state.
Anything else on that?
No, sir.
Judge, on that issue itself, I do want to state that An insanity defense in no way requires the defense to put on expert testimony. Jurors are allowed to infer what they will from evidence. This is the only documentation we have of how she appeared on that day. Our argument is not going to be that the shaking in the video is some form of insanity. It's a visual of her tardive dyskinesia, which is going to be testified about throughout the trial. But I don't believe that in any way requires for that video to be linked to our expert testimony. I believe that it's relevant for other reasons. I believe that the jury is going to be able to infer what they will from relevant evidence. They're allowed to put whatever weight they will on evidence, and I believe that's within their purview and the jury instructions.
Anything else, Counsel?
Only that to allow the introduction that without some type of limiting instruction would mislead the jury and allow them to create inferences not supported by facts or evidence.
Right. Thank you. I'm not prepared to grant your motion in limine to exclude the video. However, I will consider an appropriate limiting instruction. You'll have to fashion that, show it to counsel for the defense, and present it to me at the appropriate time, at which time I will consider a limiting instruction. Okay?
Judge, I have made 2 copies of that pursuant to the state's request, a copy that has the audio and a copy that doesn't have the audio. I'm not requesting one or the other. I don't necessarily think that the audio itself is relevant, but if the state would like the audio, I don't have really an opinion on either version.
The state would request the audio because there is a brief comment by Ms. Schenecker the state would posit is probative of issues before the jury.
That's fine.
All right, then apparently by agreement of the parties, if and when this is used, it will be the audio version. Okay? Next matter.
Judge, the defense has filed a motion in limine regarding the defendant's recorded statement. This statement was previously the subject of a motion to suppress. The state and defense have spoken about potential redactions to the statement, and I'd be asking for the following to be excluded.
All right, I've read your motion. I've gone back and read the statement, marked those specific areas you've identified. I'm going to hear from you, but first I want to know if y'all agreed with regard to these 3 specific areas that are the subject of the motion.
The state has agreed to redact part of what the defense posits as the third matter, which has to do with a traffic incident, but does not agree with especially 1 or 2 preferences.
Now, taking action for your health.
To redact, and they're enumerated in my motion. The first is on page 37 of the transcript, starting at line 17 and ending with the word because on line 23. The second portion that I'm seeking to redact is the discussion on page 59 of the transcript, starting at line 7 and ending at the end of line 12. The third portion that I'm seeking to redact is the discussion on page 59 and 60, starting on page 59, line 23, and going to page 60 to the end of line 12. In speaking to Mr. Pruner, I believe, and he can correct me if I'm wrong, that what they agreed to redact were the portions on page 60 of the transcript from lines 2 through 13. I believe is what my email reflects.
That's correct.
Go ahead. Anything else before I hear from the state?
Judge, I'll rely on my argument in motion. I believe that those items that are contained in those 3 separate portions of the statement are relevant. The officers are asking for opinions from my client and other information about the traffic incident, which my client responds inaccurately to that question, what we know to be inaccurate, and I'm seeking to redact those portions. I don't believe that there's anything probative regarding those statements. The discussion
For your health.
What are you doing? What are you doing?
those portions should be redacted.
Let's start, let's do them one at a time. Page 37. Counsel.
Your Honor, my argument as to each are the same. And at the outset, I would note that at this juncture, although counsel has filed for motion with reference to line and page, I'm going to suggest to Your Honor, at this stage, it's important that I address the content of the proposed redactions for two reasons. First, so that the record could accurately reflect the issue before this court, and secondly, because there's no way at this point our discussion of the topic of the proposed redactions can impact upon the defendant's right to fair trial. The jury is already impaneled and sworn and in a room outside of our hearing, so our conversation of it at this point, I suggest, cannot impact upon her right to fair trial or any other due process right. And I need to have access to the record for appellate review fully, if and depending upon, of course, the court's ruling. But as Your Honor is aware,
Well, let's start with that. We want to address these matters one at a time. Counsel, he wants to be able to refer with specificity to these matters that you earlier asked and were earlier ordered to be sealed. So let's address that issue.
Judge, I believe based on what is already contained in the court file, the transcript is contained in the court file under seal, so there will be an accurate reflection since it is noted line and page, which areas we're seeking to limit. I understand we have selected a jury, but the media coverage is ongoing in this case, and although we instruct the jurors, I would like to limit and guarantee my client's right to a fair trial as to any statements that may not end up being admitted in the trial. What I would suggest is either we make the argument at the bench or in camera regarding the actual line and content of the statement if it is something that the state is seeking to argue.
At this juncture, I'll offer the opportunity to come up here if you wish, Counsel.
that's fine, Judge.